10 seconds to go. Start. This bill has been brought forward for the purpose of amending the 1954 Act, which originally applied to Part A state high courts, but after the reorganization has been so adapted as to make it applicable to all the high courts in the present states. Formerly, so far as the then British India was concerned, we had the Order of 1937 under the Government of India Act of 1939. That act or the order was in force as appropriately amended or adapted from time to time. Then you are aware that the Constitution was passed, and according to the Constitution, certain rules were laid down both in the body of the Constitution itself as also in one of its schedules. So, certain conditions of service were specified as, for example, the question of the remuneration of the High Court judges and the Chief Justices in the various High Courts, but some matters remained, and therefore in 1954 an act was passed by Parliament so far as the then Part A state high courts were concerned. Before that, sir, you are aware that after the integration of states, we had under the Constitution what was known as Part B states, and there were high courts therein. So far as these high courts were concerned, an order was passed in 1953 governing the conditions of service of the Part B state high court judges. Subsequently, after the reorganization of states, you are aware, sir, that advantage was taken of the amendments to the Constitution in certain respects so far as the High Court judges were concerned, and those amendments actually came into effect from 1st November 1956. Thus, you will find, sir, that from 1st November 1956 we have the High Court Judges Act of 1954 duly adopted after reorganization. That is the main act, or as it is sometimes called the Parent Act, which is now sought to be amended in respect of certain matters. One is with regard to leave, and it is considered necessary to specify certain circumstances. The second is about the making of some of these rules applicable to additional High Court judges because a special provision was made in the Constitution by the 7th Amendment. Now, in this bill, it has been made clear that so far as these acting judges and additional judges are concerned, their service as such will be counted for the purpose of pension only if they are subsequently made permanent judges. Otherwise, for example, if no such provision was made, then their service for the purpose of pension would be counted only from the time they are made permanent. But here it has been made clear that in case they are made permanent, their previous service as an acting or additional judge will also be taken into account for the purpose of their pension.